So good afternoon, everybody, and welcome to the King's Chambers Employment Team talk. We're doing a series of sessions throughout the year, and this afternoon, I'm going to be talking to you about neurodiversity in the workplace and in the Employment Tribunal. For those of you that don't know, I'm Laura Gould. I'm a barrister at King's Chambers, practicing in employment, commercial and sports law. I'm also going to be giving the talk today with Rachel Senior, who is my pupil. She's in second six at the moment, and so she's on her feet now and available for work, although her diary is getting fairly full at the moment. And she's going to introduce herself to you and start us off with this talk. So without further ado, Rachel.
Thank you, Laura, and good afternoon, everyone. It is my privilege to be able to kick things off today, starting out by just outlining some of the terminology that we're going to be discussing today. So what is neurodiversity? The first bullet here is a definition I've taken from the ACAST guidance. So neurodiversity refers to the different ways the brain can work and interpret information. The term neurodiversity was coined by Judy Singer, who's an Australian sociologist. And she draws parallels between neurodiversity and biodiversity. Essentially, the way things are different in nature is also the way that people's brains are different, the way that we work and interpret information. So what is neurodivergence? So that again is how the brain processes information differently. And it's estimated that around 15% of people in the UK are neurominorities. Some people put that slightly higher, at 15 to 20% of people. Neurodivergence is sometimes described as a spiky profile, and this image here shows what that spikiness means. At the bottom you have different types of characteristics. This is taken from Dr. Doyle, who is an expert psychologist and specialises in organisations and how neurodiversity affects organisations. So here we have a profile of a neurotypical person demonstrated by that straight line. So those sort of cognitive functions with that straight line would be what are considered neurotypical. Then someone who has a spiky profile would see these different types of cognitive abilities, some much higher than a neurotypical person and some lower than a neurotypical person. So neurodivergence is an umbrella term that includes a range of conditions. I've listed them here. The thing I would particularly draw out on this slide is the prevalence of these conditions is, in some cases, quite high in the population, so we shouldn't be surprised to see people with these different types of neurodivergence, and the different labels for types of neurodivergence are included on this slide. The other point that I would make is that these labels often co-occur, so they're not discrete categories. It's not a matter of individuals falling into one category. Individuals may fall into multiple categories. And as well, these categories are only one type of category that a person may fall into. Obviously, people may have other sorts of protected characteristics. And without further ado, I will now be handing back to Laura, who's going to be able to draw from her wealth of experience in the Employment Tribunal. I'm, of course, starting out in my second six, but Laura has many years of experience, which she shares the benefits of with me, and now hopefully will share with all of you as well. Over to you, Laura.
Thanks very much, Rachel. Yes, many years of experience. I've seen the sign-up list, so I think some of you will be as surprised as I am that I've reached the years of experience that I now have my own pupil. But here, let's go and use some of that experience to give you some practical tips and ideas about neurodiversity in the workplace. And just whilst I'm talking about this, please do feel free. You can put some chat in the chat if you want, but we have got the Q&A function working. I'll be coming back at the end to answer some questions in there, whilst Rachel is just giving us some concluding points, and we'll also have a Q&A where I can answer those orally as well as in writing, but feel free to pop them in there. So neurodiversity in the workplace. Well, Rachel's giving you an idea of what neurodiversity is, and what I'm going to focus on through these slides is mostly autism, autistic spectrum disorder, Asperger's, ADHD, attention deficit hyperactive disorder, because they're the two main areas, if I can call them that, many different headings depending on the particular presentations. But autism and ADHD are the two main areas that I'm seeing quite a lot of in Tribunal, and I would say I have been now for certainly pre-pandemic, so say sort of 4 or 5 years, and it's been ever increasing. And that's both in terms of claims that are brought, but also the way that people present, even if it's not the actual basis, say, of a disability discrimination claim. I also do see a fair bit in relation to dyslexia, but that's not the area that people or employers in particular tend to struggle with, because I think there's been a longer standing, deeper understanding of what that can involve, not so much with ADHD and autism. So that's why I wanted to specifically focus on those two areas. So first of all, starting off in the workplace, well, this is an area where there is a very fast growing understanding of these two conditions. Up until recent years, it would have been envisaged to be just young, usually white boys that were considered to have ADHD or autism. And that's very much not where, obviously I'm looking to focus from an employment perspective, but it's not where these things end. And it's worth knowing that in terms of how neurodiversity presents, it presents in many different ways, even if it's under the same definition. If it's in, a man, a woman, obviously there are differences between those individuals that can then affect their presentation. So there's an awful lot of education that is developing in this area and understanding. But whilst that's happening, of course, some people might read one article, someone might read another. So one person might have an experience of neurodiversity, someone else might not. And so I would say we're still at the stage where people can get the wrong end of the stick, where people are still jumping to conclusions. And that can cause some of the difficulties that I'll come on to look at in terms of actual claims. So what can an employer do and what can colleagues do? Well, they can start by educating themselves. There's an awful lot of information out there that is actually very readily accessible, particular organizations set up in relation to various different neurodiversities or divergences, and focusing on the specifics as well. So differences, for example, ADHD in women, autism in young children. There's a lot of different materials out there. Yes, you will still find it's largely focused on children, but there's an awful lot more out there. So educating yourself is a good starting point. Think about what it was like 15 odd years ago, when we were starting to see more and more anxiety and depression claims. And there was an awful lot of misunderstanding about it, some negative views. Yes, they still persist, but not in the same way as they did. So that's the sort of developmental stage, I say, that we're going through with our understanding at the moment. Also, because of these various different organisations, there are training opportunities out there. And so depending what sector you're working in, if you think you have a potential, not necessarily large number, but more than minor number of employees who might have neurodivergences, could well be worth bringing in some training, because it's not just how do managers deal with it, but it's about how do colleagues interact with each other as well. So that's always a good starting point. It is in respect of any disability, but particularly with this area where there is a growing number of diagnoses. That's not to say that there is an increase in the number of people who had, for example, ADHD or autism, but more people know that they do now. Communication too. I'm going to come on to quite a few specific tips in terms of communication. But again, this is an area, because it's developing, from my experience, I'm finding that employers can still be either nervous about how to deal with employees who are autistic or have ADHD, just in terms of how to communicate about it. If there is a particular issue, if there is something that they want to talk about, if someone does get the wrong end of the stick, worrying and approaching things with too much of a kid gloves approach, which can actually end up making things worse. So you'll see me say a lot through these slides about I use the word empathy. And what I mean by that is trying to put yourself in the other person's shoes. Now, you can't have that other person's lived experience, but you can educate yourself as to what they might be going through, the best ways potentially to communicate with that individual, to open up a line of communication, to have the open and frank discussions, to have those recorded well so everybody knows where they stand, and to have those communications from a much earlier stage than, frankly, the cases I see, where things have either on one side, the other, or both, spiral to a situation where litigation becomes inevitable. So again, communication is going to be really important here. Support in the workplace. Well, depending on your size of workplace, you might have a disability network. If you are that big of an employer, there's every chance that you've already got, it might be a neurodivergent board or group as part of that disability network. brilliant if you do, but be engaging with those people who have stuck their head above the parapet. We're seeing more and more people disclose their own neurodivergence at the moment, and they're saying, yes, we want to do something about it, we want to communicate, and see that as a constructive tool. Obviously, many employers are not on that side, so they won't have those sorts of groups in the workplace. But just last week, it was Neurodiversity Week, and there was a huge amount of information that was put out by various different organisations, companies, people talking about their own experiences. Now is a brilliant time to go back and draw on those particular areas of information that were being shared to see, is there something that's particularly relevant to your field, to a case that you're dealing in? And just really, again, coming back to that empathy point, be prepared to listen to the person that is telling you about their experience. Because this is an area, as we've seen in the past with anxiety and depression, where you can have some people on one side saying, well, show me what it is that's making you feel like that. And the other person saying, but no, I am feeling like that. And it's not necessarily that easy for me to show you why. Now, we're lawyers. We want to see every evidence for everything. But this is a matter of industrial relations. And I'm not saying you have to necessarily accept what somebody is saying as read, but maybe challenge yourself or challenge the manager or employer that you're talking to as to, what's really the problem? If we just accept what they're saying as to that's how they perceive things and this is why they perceive it that way, even if we can't see the objective evidence, does it actually cause us a problem to engage on that basis? And I think these are the sorts of things that you'll come to get a better feel from the more you engage with the concept of neurodiversity and the many different ways that it can present. So as I say there, key empathy and understanding. And in this context, I say they're one and the same thing. Listening to people, being open to what they've got to say, even if it challenges your own perceptions of what should actually happen in the workplace. And then look at these things as a positive. There is arguably, I would say, a move away from this is my superpower. Some people very much still engage with that and do see their neurodivergence in that way. Others not necessarily. You don't have to hold it up to that high of a standard. But the more you understand about, and frankly, this is all we're talking about, the way a person's brain works, the more you as an employer can go from, instead of seeing, well, this is just someone who's asking me for reasonable adjustments and therefore wanting me to do something different and that's challenging, to actually, well, what is it that this person's really good at? Are there areas of jobs that maybe within a team could be restructured here because they're particularly good at this thing that maybe a neurotypical person wouldn't find quite as easy to do? For example, it could be managing projects with dealing with lots of different things at the same time, communicating, or it could be with a different presentation, going into lots of detail. So have a think about how to use the individual skills best and have that conversation with them, make them feel valued. And as I say there, think diversely in terms of how you're addressing matters. Now, moving on, obviously that's a positive way of looking at matters, but we're litigators. We know when things come to us, the positives haven't always borne out. So what are some of the issues that I see once things get to tribunal? Well, one of the problems that I've seen over the years, and is, I think it's probably reducing in a sense, is that when it comes to people who have ADHD or are autistic, the way they present can vary. The way they present will vary from person to person. It can vary from day to day. It can vary from task to task. And that in itself can be difficult for colleagues, managers to accept. We all know when people say, oh, they're just putting it on, or, it's not really a problem. We see those sorts of comments still, unfortunately, in mental health. The reason I say that's probably diminishing in my experience is because I think people are more open in talking about either their diagnosis, and I think we do have to recognise here this is an area that's really underfunded, so it can be very difficult for somebody to actually get a diagnosis, or what they believe to be their condition because they haven't been able to get that diagnosis. And so I think that can help, because one of the traps that employers do still fall into, but I particularly used to see happen, was when you might have somebody who was very black or white in their thinking, struggled with empathy, didn't see it from another person's perspective, and had a very strong sense of justice, so didn't want to back down from a situation. And the employer was taking that at face value as someone being difficult and maybe refusing a reasonable management instruction, or usually not quite that high, but not creating the best employment relationship. When actually, if they'd known that person was autistic, they might have been able to understand more. And of course, as we'll come on to look at, you don't always have to know everything to fall foul of the Equality Act. Some other tips are communication styles. Find out what works best for that individual. It could be bullet points. It could be written. It could be oral. It could be lots of headings and then sub-bullet points. It could be that they'd rather have everything in one email, so they're not getting pinged all the time, or they might prefer to have them in bite-sized chunks because otherwise it can be overwhelming. Could be a physical reasonable adjustment. So coloured paper, for example, can be something useful for people with certain presentations of dyslexia. But the sooner you find these things out, yes, I know you've got to have an indication somebody's neurodiverse, or even better if they're telling you, but having that conversation rather than just saying, what reasonable adjustments do you need? And then at a later stage go, well, you didn't tell us any. And then you get into that cycle of, but the duty is on the employer to make reasonable adjustments. And what did you know? And what should you have worked out? Just having the conversation and having a structured way to have the conversation. So a manager feels supported with these are the points we want to go through. This is why we want to go through it. Having a manager understand some about it. And so they can come to that discussion with a level of empathy that then makes the employee feel valued. And I'm not saying giving the employee absolutely everything they want without question at all. And we'll come on to see some reasonable adjustments in Tribunal, where I think there's a real difference of opinion that could be taken as to what's reasonable or not. But having a structured conversation and going back to the basics of why are you asking this? What are you hoping to achieve? It's still employer-employee relationship, so we might not be able to give you everything, but we'd really like to understand what it is that you say would help, how we can get these things right to avoid the problems further down the line. And this comes back to, and this is another point I'll repeat, about not assuming what might work for an individual. So again, I say empathy here, taking the heat out of the situation. It's another reason to get ahead of things with finding out, for example, communication styles. So you're not having to have that conversation when the problem has already arisen. You're having it at an earlier stage as a positive, proactive step rather than trying to undo a falling out that might have occurred or a misunderstanding. And that can really help to take the heat out of the situation. And I've put there, is a reasonable adjustment really not reasonable? And I flag that because that's something I see in tribunal claims. Both sides, all stages throughout the litigation process, depending when I've got involved, of a refusal to a reasonable adjustment because it's slightly out of the ordinary and it might take a bit of effort. And sometimes it feels as though perhaps the thought process behind the refusal is this person having me on? Actually, they're very smart, they're very capable, they're managing to make things work. I don't understand why it's become a problem now and why they've had to have time off with stress, etc. It's that lack of empathy and that lack of proactivity. And so questioning, if you're refusing a reasonable adjustment, is it really not reasonable, or is it just a little bit of a pain? And as we know, that's just not going to be good enough. And it's not only doing it because you have to do it, but doing it because it keeps that person in the workplace, and you're using someone then effectively that you wanted to employ in the first place, most of the time, obviously leaving aside cheapy situations, but you wanted to have them there. So finding out the best way to use their skills, and just accepting that sometimes you will have to take steps that maybe in the past you might not have thought were necessary, but you might find in the long run actually aren't that problematic. And the classic example is working from home. I had cases both before, during and after the pandemic, if we can say we are now, about working from home and the swing in views from that being completely unreasonable to actually realising what could happen. And yes, we know some employers don't want people working at home because they have concerns about how effectively they're working. Are these concerns borne out? Maybe, maybe not. But look at it on an individual basis to see whether it is, because that's what we're thinking about here. And also we have other employers who think it's great, particularly with hybrid working. And there's often room for compromise in these situations that could keep everyone happy, for example, with hybrid working. And seek external support, advice, guidance. As I've said already, there are materials out there, and the amount of materials that are out there are ever increasing. And I'll just put in here some challenges for the newly diagnosed, and I think this is something worth saying to help with the empathy I've been talking about. The Kubler-Ross model, many of you will recognise that from when somebody goes through a process of grief, when they lose a loved one. Denial, anger, bargaining, depression, acceptance. And it's very much recognised that's something that a newly diagnosed neurodiverse adult goes through. You may have seen in the press, there's been an awful lot over the last year or so about women in their 30s getting diagnosed with particularly ADHD, presents in a wildly different way to what would have been expected in young boys, gets missed at school, they're often gifted, start to struggle at a later stage. Everybody's surprised by it because they've always been able to cope so well. And now you're starting to see an increase in diagnoses. And of course, it doesn't mean that they've only just developed ADHD. It's that they've managed to what's called mask and fit into the world around them up to a certain point, and then it's got too much. And if they'd been young boys at school and presented in a way that boys were expected to, they might have been diagnosed at a younger age. Something we're seeing happening more in schools now, and understanding and awareness, but it wasn't there in the past. And so people go through the process of denial, thinking, well, no, I don't have this. I don't need a label. I've got by this far. I must be okay. Anger can be a very big one for people in terms of feeling that they've not met their full potential because they haven't been supported in the past, because people didn't recognise this. They've not been medicated or been able to understand why their brain was working how it was. Moving on to bargaining, trying to sort of find ways to make this go away. Depression, you can imagine again with the anger, if you look back and think, God, this could have all been so different, how challenging that can be, particularly for these high achievers who then may have burnt out, and that's the reason why they eventually seek psychiatric support. And then eventually to acceptance. And again, you will find a lot of information out there from people who have accepted their diagnoses, and it's been very constructive for them. But it's quite a process to go through to get there. But what does that mean in the workplace for those who are newly diagnosed? Well, I think recognising that if somebody goes through a diagnosis process, it can take a long time, and they eventually get the diagnosis at the end of it. You can't just expect them to know everything the next day as to now how their brain works, how best to manage that in the workplace, or to be okay with it. Once you get the diagnosis, you're not at the end of the process of acceptance. You can still be very much on this this journey and going back and moving forward again. So adaptations, reasonable adjustments, you can end up with a trial and error situation because the individuals might not know what works for them. Be patient, be constructive, be supportive. As I say, these were people you wanted to have employed in the first place, and recognise that this isn't a light switching on, everything's all okay. And again, I come back to thinking, how can the employer help with discussions about what could happen, actually thinking and applying their mind to a reasonable adjustment rather than just saying, tell us what you think it should be, understand how this person best functions as they understand it, and try and be constructive with some suggestions, and then think about how that can help you as a business as well. So as I've talked about, there's physical adjustments, but also PCPs. And I think it's very helpful, I have found, in the cases that I've had touching upon neurodiversity, for somebody to understand why. Why are they being asked to do something? Why is something needed? Why is there a conversation about this? And it can really help to set into context what it is that's being asked of them, why a meeting is taking place, etc. Having an open dialogue, having notes. As Rachel touched upon, the processing of information is often something that can be different. I don't want to say impaired, because sometimes it's better, sometimes it's worse, sometimes it's fluctuating. But that processing of information can be varied and different to a neurotypical person. So having notes, agreeing them in a moment, asking somebody to follow up and tell you if they think there's anything wrong, always good practice, but doing it even in what might be slightly more informal meetings than we might ordinarily, and explaining to someone again why you're doing that, to try and make sure that you all understand what's being discussed and where we're going for everybody's benefit. And if you say, well, no, I'm sorry, we can't actually make that adjustment, again, explaining why. The person might not accept it, but I think in any case, even if we're not talking about neurodiversity, explaining to someone why, rather than just pushing back with a blanket no, can be really helpful, in either furthering the dialogue and being open to someone talking you around if there is a bit of debate that could be had here, or just trying to gain that understanding from both sides, so there isn't a feeling from the employee of, oh, well, no, they don't really want me here because they're not prepared to help. Some practical tips in work and in litigation. Plain English. Well, that's true for any case, any correspondence ever. But I would say even more so with people with different styles of processing information. Leave the legalese at home. We're employment lawyers. It shouldn't be in there anyway. I've taken, actually, after hearing someone say this in a completely different pleading context, but really trying to shorten my sentences. Where there's a comma, could I actually make it a new sentence? Where there's a full stop, should that actually be a new paragraph? And looking at that, I think I found my writing is far easier to follow than it was before. And hopefully those of you that have instructed me thought it was easy to follow before, but I've really seen some improved clarity from breaking it down into shorter, punchier sentences even further. Clear, direct language. If you're saying anything technical, further and better particulars, additional information, changing that language around. And as I say, just using plain English. If you're talking about a case, tell them why you're talking about the case. If you're going to quote something from it, quote something from it. If you're not, do you really even need to actually mention it? Or if you are mentioning it, could you say, well, I've given you the ideas of these cases in case you want to read up on them. But, they're the standard cases that would expect a judge to know. Something like that. So you know why it's in there. Ask, listen, and actually hear to what you're being told about how best to communicate. And I'd say that goes also when you're litigating against a litigant in person or you're acting for a neurodiverse person. Again, don't just assume. If you're on opposing sides, think about being collaborative. Don't take a sort of combative approach. So as I say, again, just don't assume. Have some good levels of empathy here. And when it comes to in the workplace or if you're advising pre-action, think about why the grievance has been made and are there actually practical solutions that could be put in place, at least to knock away a few of the concerns so the whole picture doesn't look quite as overwhelming. Because I don't want to generalise, but there can often be seen in these particular neurodivergencies or divergences, a real sense of fairness and justice in an individual. And I think many of us can think of cases where we've been involved in a case where it's someone who is autistic or has ADHD, and there can be circumstances where they're extremely principled, and that matters beyond anything else. We often say when someone says it's not about the money, well, it always is, and then you find these cases where it's not. And if you can understand what it's about at an earlier stage, that can really help to challenge some of the problems that might arise. And then having diversity in your own team, recognising, celebrating and supporting neurodiversity. So you'd have other people, managers potentially, that you can go to ask that you've worked with before, buddy systems, etc. Or people in the workplace as litigators who have experience of neurodiversity that might be able to help if you've got a particular communication issue, a barrier that you can't get past. So moving on to a little bit of the law. Disability, I've put the definition in here. I have some thoughts about whether it's a mental impairment. And I think ultimately what matters is it depends on a case-by-case basis. It's one of those situations where people talk about not fitting into the world as it's made for them. And so it's always a question here, do you challenge disability? Now, we're quite willing to accept anxiety and depression these days, less so to accept that neurodiversity is a disability. But if you can get an early Section 6 statement, consider really, are you going to get any evidence to counter that? Even if there's only a provisional diagnosis by a counsellor or a GP, if someone is telling you what all the substantial adverse impacts are on their day-to-day activities, are you really going to be able to counter that evidence? Now, you can give it a go if you want to, but think about it pragmatically is almost always my advice. Then it comes on to knowledge. This can be a real key point in disability cases. Has someone told you that they have this condition, and do you actually accept that? Well, if they've told you, it's a fairly dangerous point to go back on and dispute that. Rachel will give you a bit of a summary later as to some ways in which that can actually, a tricky issue can be, have the tightrope walked in relation to that. Constructive knowledge is often more what's disputed, but what are the indicators? And this comes back to the training and insight into these conditions. Again, we would know, for example, if someone starts taking persistent absences or turning up late when they wouldn't ordinarily, and behaving in particular ways, that can be an indicator of anxiety or depression, mental health issues. And I think we'll have to accept that more and more there are indicators that will be accepted that could open a conversation about neurodiversity. What evidence is there? And as I say, it doesn't have to be a diagnosis from a psychiatrist to meet the Section 6 disability definition. If someone just tells you this is how they are and this is how what they struggle with, think that may well even still meet it, even without medical evidence, although I'm not sure I've seen a case without medical evidence yet. And who knows what? Check that with the colleagues, check that with the managers. It's not always just HR that know what's happening, and those sorts of things can come out later in the evidence. What about at tribunal? Well, I've broken down the claims there into the first three are perhaps less often seen but relevant. Your direct, your harassment, your victimisation or whistleblowing. And then more often you see a Section 15 or a reasonable adjustments claim or both, and then a constructive unfair dismissal. So Section 13 and Section 26, direct discrimination and harassment. You can't have both, as we know. It's got to be one or the other. You do see Section 13 pleaded, but I've not seen one that I think really would ever succeed yet, I don't think. Because, of course, that's you are treated differently because you are a disabled person. So if you were slightly under the threshold for how substantial the adverse impact is on your day-to-day activities, would you have been treated better? Probably not the easiest one to make out, as we know in disability discrimination, it usually falls to Section 15. But I flag this because it overlaps so much with the harassment claims, and that's where you do see issues coming up. Because here it's just got to be related to a relevant protected characteristic. So there's no intention needed. There's not really any knowledge needed here, because if the treatment is, as I was talking about before, because of somebody's behaviours, potentially that can be enough to be related to a relevant protected characteristic. And you don't want to be all the way at tribunal arguing that point if you can help it. What are we talking about being related to a relevant protected characteristic? Well, unwanted conduct that violates the individual's dignity or creates an intimidating, hostile, degrading, humiliating or offensive environment for them. And there is a huge range of what that can mean in mental health cases and neurodiversity, as we're talking about here. From the harsh comments towards somebody who maybe isn't very good at social interactions, bullying, leaving them out because they might be deemed odd in the workplace, through to the little by little pick of the effect of not giving someone reasonable adjustments and making them feel belittled at work, and the effect that can have on them. Much more so than perhaps we might see in other protected characteristics, where it tends to be more obvious if somebody has said something that's related to race or to sex, for example. This can be more insidious. I know it's only when you get to litigation and you look back, you think, maybe actually after everything else that happened, that one would meet the thresholds for harassment. And of course, we've always got the point under Section 26(4) of, what do you have to consider for deciding whether it's harassment? Perception of the individual. That's often an area acting for respondents that I'm really drilling down to and accepting that it's an individual's perception, but objectively, was that a reasonable perception for them to take in those circumstances, or for them to have in those circumstances? And so you're looking at all the other circumstances of the case and whether it's reasonable for the conduct to have that effect. And that brings me back to my earlier points and top tips and practical ideas of having those conversations, doing your best, trying to understand things, doing what you can to get things in place, having notes of it. It strikes me that's got to then help when you're looking at all the circumstances of the case and whether it's reasonable for someone's perception to be at a level that they perceive something to be harassment if an employer has tried to get everything right. It'll be fact specific, but those sorts of earlier steps, it would seem to me, would well help. Section 15, absolutely see cases in this area, particularly in relation to, say, dismissals or failing a probation period because of timekeeping, because of communications, because of getting work done on time, etc. that can be a little bit more difficult when someone's not been in the workplace for as long as somebody else, all very fact specific. So I'm not saying they're good or they're bad claims, the ones I've seen, but they are ones that have been brought into Section 15, and you've got to look at each individually. But of course here, yes, you need to know to a certain extent that somebody is disabled, but what you don't need to know is the key ingredient here is that there's something arising from their disability that causes them to be treated unfavourably, that actually arises from the disability, and that's the City of York and Grosset case. And so that's a really key one to focus on, either if you're pleading a claim for a claimant or if you're responding for the respondent, of you might be disputing knowledge, but does it actually matter if it's a Section 15 claim? Or in terms of the pleading and the evidence, how are you as a claimant lawyer going to say and demonstrate this is why we say the something arises from a disability? And I've seen that done very well, and it's usually a bullet pointed, these are all the adverse impacts of my day-to-day activities, and then linking it up to what was the something, what was the unfavourable treatment, to create that clear picture, rather than just a lot of waffle around what actually happened. That sort of punchy pleading, it certainly makes the case clearly, whether it proves it or not. And I'd say at this stage, you can't rely on judicial notice as you might do for perhaps depression and anxiety. Then if you're pleading a proportionate means of achieving legitimate aim, whatever the disability, specify what were the proportionate means, and most importantly, what was the legitimate aim that you were seeking to achieve. The sooner you get that in there and apply your mind to it, not only the better for stopping the tribunal from having you go at preliminary hearing stage or final hearing stage if you haven't put it in, but the sooner you plead it, the sooner you'll identify if there's a problem in that particular part of your case. Reasonable adjustments, well, I've covered some of these points already, but does the PCP just apply to that individual, or is it a wider PCP? And some of the issues that I've seen come up where you still see that problem between someone's attitude towards neurodiversity and what the individual is actually experiencing is things like what time they start in the morning, whether they have to be on time, whether it can be a bit later, whether they can make the time up at a later stage, because there can be real issues in terms of what's called time blindness, people thinking that they have more time than they do. It's a difficult one for people to accept when they first hear about that, but if you read up on it, if you speak to people that are neurodiverse, it happens again and again and again. And it's not something they are ever wanting to get wrong. It's not a lack of respect to the employer, other than if they have that as an attitude generally, but that's not part of the neurodiversity, but can be a real issue for employers because they see it as a lack of respect. Method of communication and feedback, as I've covered already, particularly on the feedback, having that be constructive and clear. One area that can come up in these neurodiversities is something called RSD, rejection sensitivity dysphoria, where individuals can be particularly sensitive to criticism. And if you understand that, and again, explain why you're giving this feedback, make it constructive, do it in an appropriate manner and time, again, can help to show you're trying to do the right thing to build a good relationship and not immediately move to a bad relationship. The amount of work, individuals can often be very keen to people please and say yes to too many things. And the variety of work, if it's someone that needs to be kept interested with a more variety, or is it someone that wants to focus on something very, very specific and detailed? I accept that's not all going to work in every single employment situation, but understanding it, accepting it in good faith, and then seeing is there something you can do about that to make it work, I think that can really help, even if it comes to you being at tribunal and defending your position. If it doesn't resolve it, applying your mind is often something that we see missing in mental health reasonable adjustment claims that make them harder to then evidence. And working from home, as I say, used to be a big no-no. Now we're not in the same place. So again, is it really not reasonable? Grievances and whistleblowing, I only touched upon that briefly. Again, going back to, it's a slightly general point, but as I say, from my experience, people having a very strong sense of justice, right or wrong, might be more prone to make complaints that then lead to a Section 27 victimisation claim, or to blow the whistle and to really stand by it and not want to back down from it. Because of that sense of justice, it can seem to be entrenched. have a think about alternative dispute resolution, have a think about mediation in the workplace. Frankly, if you're a big employer, have a think about training some of your staff in mediation to be able to deal with these points rather than just going through your standard grievance process and ending up in tribunal. Constructive dismissal, implied term of mutual trust and confidence cases. And again, key issues you'd be looking at here is, was the employer acting with reasonable and proper cause? That's often where I find the focus of my arguments are. What was reasonable? And that comes back to, yes, there's a reasonable adjustments point, but actually here it's looking at it from the employer's perspective. And then again, objective or subjective perception. That's where a lot of my cross-examination ends up being focused. So some tips in the employment tribunal. There can be an impact on claims, as I say, whether it's a disability, neurodiversity related claim, or whether it's an individual who, through a sense of justice and ability with detail and wanting to pursue matters, etc., ends up in tribunal, but for a different type of claim. And I'll take you through a few of the points that I've listed there. So correspondence, again, listen, empathise about how best to go about that. Make use of ACAS. Even if you're not hearing back from the other side, go back through ACAS. I think in most cases it helps to have that individual in between if they're acting on behalf of themselves. Again, plain English direct. Why? Don't surprise them with new documents or information. Really try to, every case we want to have it well prepared. Don't want to be having new documents disclosed at tribunal or even at a preliminary hearing. But really try to make sure that's done in advance and think about instructing counsel early to do a chronology, a list of issues, a cast list, all of those sorts of things that when we do it, that's when you identify something is missing at an earlier stage when you're collaborating on those documents. And so be prepared further in advance, because you don't want to end up in a tribunal, for example, where you're looking at dealing with documents last minute, that with a neurotypical person, you might say, well, come on, we can deal with this. Or with a lawyer, you would say that. And actually the judge thinking, well, hang on, no reasonable adjustments, we're going to have to adjourn here or lose more time. So it is to your benefit to do it. It's not just helping the individual litigant in person. Time limits, everything goes back to a DG now. That's the real summarising case, bringing everything together on just an equitable time limits. And I've just quoted the key point there where it's about assessing all the factors in the case. And of course, the tribunal have got to take into account reasonable adjustments for the individual that they're giving them. And key issues are length of and reasons for the delay. I don't think I have seen yet a time limit be extended purely on the basis of neurodiversity, particularly if the individual has been able to prepare other documents, but it's an arguable point for sure, and it's going to depend on how they present and how best they explain their case to the judge in terms of what were the particular problems at the time, how badly had it affected them in terms of the breakdown at work, for example. Case management hearing, list of issues, do it in good time. Something I've started to do is very detailed questions, written questions for further and better particulars. And I don't mean detail as in a lot of waffle, but potentially 30 questions where we set out in advance of the preliminary hearing exactly what our questions are. And then, so we'll set out what our questions are and then give the litigant person an opportunity to respond to them in writing in advance of the preliminary hearing. If they do, great. I found it works really well. But even if they don't, it gives you a much clearer roadmap to work through on a preliminary hearing. And I think it can be particularly challenging on telephone when you can't see when you're meant to speak, for example. So it could be that there's a request for it to be done by video. For example, if you're acting for a claimant and they want to observe it, you might not raise it as a respondent against a litigant in person, but it depends on the interactions you're having. Agenda, again, explaining what it is and why, and trying to get a joint agenda so that you're dealing with fewer documents can be very helpful, again, for any litigant in person. And if you're challenging disability, explaining why in clear language in advance, explain what you're asking for in terms of what is a Section 6 statement, use plain English again, and why you're asking for that, because obviously we know people can take offence and think that there are actual disabilities being challenged, and where there can be additional issues with processing information, for example, better to get out ahead of it. Case preparation, again, doing it in good time. Do you want extra stages? Is it better, for example, in disclosure to just do everything by document? Don't even worry about the list. You'll do that in the index. Or is it better for them to list everything first? Building in lots of time in case there's any slippage in the timetable on both sides, because we know how litigants in person can feel that it's unfair if there's slippage on the respondent side as well. So trying to avoid that by having enough time in the timetable and asking a tribunal for that when you're dealing with a disability case. Be clear what's going to happen step by step if you're corresponding, and say if an issue comes up over specific disclosure, very clearly explaining why we're not at that stage yet, if it's before the preliminary hearing or afterwards, why are you disputing it? And again, punchy bullet points rather than lots of paragraphs and legalese. If there are disputed documents, I'm not saying roll over on it, but explain again clearly why that's an issue. And if you can't come to agreement, don't fight forever about it. Put it at the back of the bundle. Unless you're in Bristol and you've got page limits and you've got word limits, and then you need to try and do something about it. But again, there's only so much you can do. And if it's a case of writing to the tribunal and explaining the position, saying you'll put it in a separate section, and proportionality dictates we'll ask the tribunal to deal with this at the final hearing rather than have another hearing, doing that before there's a whole load of correspondence where you're never going to agree, again, probably the best use of your time. And you might want page limits. That might actually be constructive. Again, you might have an idea about that from any DSAR that you've been involved in, and how the individual's dealt with that. Witness statements, not really an issue from the representative side, but always headings, subheadings are useful, and you might find word limits are for the same reason, to keep that focus. Final few points, some reasonable adjustments in terms of preparation or physical reasonable adjustments for a final hearing. Raise these before a preliminary hearing, have the discussion in the preliminary hearing, refine it afterwards if you need to, but don't leave it to just be discussed in correspondence shortly before the preliminary hearing. Have a discussion of what's actually going to happen in the final hearing, what are the expectations on the litigant in person, or if they're your client, what's going to happen. Timetable the final hearing so everyone knows where they stand. It's easier to plan and process your information knowing that in advance. Again, preparing well in advance. If there's going to be any technology used, recordings heard, how's that going to happen? Who's going to do it? Try and get out ahead of that at the preliminary hearing so you're taking all those concerns off the table. Does there need to be a particular colour of paper for someone who is dyslexic? What about lights or noise? Is there a particular room in the tribunal that is better or worse? For example, in Manchester, one side you're near the roads. There's been a lot of roadworks there for quite some time. I had a case where Judge McDonald very helpfully managed to move us across the corridor. So it was quieter. It was also, the light was better in there. We were able to open the windows. So it was cooler, the air was fresher. All these things, if you understand the person's presentations, can be very helpful and not that difficult to address. So ask questions in advance, have some correspondence in writing, and have a discussion about it at the preliminary hearing. At the final hearing, or some conceptual issues, should it be in video? Should it be in person? Should it be a hybrid? You might find that the individual wants to give their evidence on video, but wants everything else to be in person for them to observe. Potentially, you can use waiting rooms in the tribunal. So again, Manchester's a good example where there are conference rooms, same in Liverpool, not available everywhere, but it's something worth having a discussion about. Can there be a private waiting room? So for example, in Leeds, would you be able to reserve one of those waiting rooms? Let the tribunal know in advance. They are constructive when they have the time to think about it. Do you need more breaks? Should there be more pauses after a question and answer? Do you need to slow down how quickly you're speaking? Obviously, I wouldn't go this speed in cross-examination, but I appreciate we're approaching 5:30 and it's a Thursday. Again, lights and noise at the actual hearing. Some understanding, if you're representing a claimant, explain, well, they might have a anxiety ring, a fidget toy, they might bounce their leg. Judges know about these things from the Equal Treatment Bench Book, but it's always good to raise it for everybody as a reminder. Just like we would do if someone had a bad back and we say they might have to stand up and walk around. Again, these are some of the points that we'd want to flag, but from a mental health perspective. Communicating, asking questions, that's a matter for the advocates. Signposting what topics we're going to be covering. try and give an idea on how long it's going to take, break them down into chunks, even under those headings, so everyone's clear where they are. That's good advocacy anyway, but again, can help somebody with processing issues. Is a break overnight a good thing? Do you want an actual split hearing where it's, 2 days, 1 day off, 2 days? I've had cases listed like that where someone says they need a break after they've given evidence before they can start with the other side's evidence. Or is that too stressful to have a break overnight? Do you need to make sure you're starting this witness at 10 a.m. because they want to get it done in a day? Just be open to it. It doesn't generally cause any problems. And what witnesses do you really need? If they're going to be cross-examining, it's much easier for us as advocates to say, what do we not need to ask questions on, than it is for a litigant in person. So again, what evidence needs to be in there? Is it better to have something, say, in a reading list because all you're doing is introducing the documents? And what questions do you actually need to ask the individual from an advocate's perspective? Do you need to have a massive run up to the wicket, go around the houses? For example, with someone who's dyslexic, the first time I ever dealt with a case with somebody where that was the basis of the claim, I've always asked them, it was an astonishingly few number of questions. And it really does make you think, actually, do I need to be doing this most of the time? Sometimes, yes, but be even stricter with yourself than you would be ordinarily. Settlement, again, comes back to the point I made earlier. What is this person wanting to achieve? What do they see as justice if that's what they need to remove themselves from this situation? I've put at the bottom there, is that an apology? Is that actually a problem for the company to give an apology? Is there a way of wording it that is useful to everybody rather than just going back and going, no, we never apologise? Again, using ACAS, absolutely using judicial mediation. Not everybody's favourite tool, not always the most effective, but it can be extremely useful, particularly where somebody is representing themselves, to feel heard by a judge, even when the judge isn't making the decision. That's true, I would say, for most litigants in person, but particularly I found in situations with neurodiversity where somebody wants to feel they've gone through a formal process with an independent individual. Is it a high value or problematic enough case, for example, someone's still employed, that it's worth going to commercial mediation? And do you do what I've been instructed to do in the past, which is pay for a representative for the other side? So that if it's a litigant in person, they can be represented at a mediation that can go well outside the timings of a judicial mediation, but to try and get something resolved. Absolutely not right in most cases, but keep in mind that is an option, and occasionally it can be very useful. Will this person want to see the disclosure? That's probably going to depend on at what stage you're suggesting mediation. The earlier, perhaps the less likely, but we know with DSARs now, not necessarily. Could that just escalate things? But that's worth bearing in mind as you're assessing each case. And how much confidentiality do you need as compared to them wanting to be able to talk to their friends, for example? Probably not a thing a respondent would want to give up, but worth bearing in mind in particular circumstances as to what can be said and maybe agreeing a form of wording of what can be said. So that's an absolute rush through my bit. Sorry to keep you a few extra minutes possibly, but Rachel's just going to give you an example of a case where some of these issues actually did come up before I answer any questions, and I'll just quickly deal with that one that's online.
Thanks very much, Laura. I had the great fortune during my first 6 to be supervised by James Boyd, and hot off the press for you all today, about a week and a half ago, the EAT released the judgment in McQueen and the General Optical Council. This is a case that was exactly centred on the issues that we've been discussing today. The respondent agreed that the claimant had dyslexia, symptoms of Asperger's syndrome, neurodiversity, and left-sided hearing loss. And the central issue in that case was the consequences of the claimant's disabilities, in particular those that caused challenges with meltdowns at work. And there was a question in the case about whether the source of the meltdown in some occasions or in all occasions was because of the claimant's disabilities. And again, that section 15 test is on the slide there. What the EAT found is that once the tribunal had determined that the disabilities didn't have any effect on the conduct on the occasions in question, the question about whether the unfavourable treatment was because of that conduct didn't actually arise. So what the Employment Tribunal had found was that there had been a couple of incidents of meltdown that had led to various consequences for the relationship between the employee and the employer. but actually those meltdown occasions were not caused by the disability, although other meltdowns could have been. So it's just an example of how the EAT has wrestled with these issues, particularly in a Section 15 context, where we're looking at issues of causation and what leads to behaviour, and whether that's something medical or whether that's another aspect of the person's personality. Now, how do you disentangle those two, which can certainly be difficult. So I would highly commend that judgment to you, particularly if you're looking at a Section 15 arising from claim, because the judgment sets out very helpfully, especially at paragraph 52, the kind of questions that need to be answered in the process there. Back to Laura.
Thank you very much, Rachel. If anyone's got any extra questions, if you want to put them in the Q&A or the chat function, but we've got one here, which is asking about someone who's saying that a person's processing and working memory affects almost every aspect of the tribunal. And I've certainly had that happen. And here the tribunal's talking about appointing a course intermediary to prepare a report and then have a ground rules PH. I don't have any experience of that. And it's really interesting to hear that that's what the tribunal will do, because we see that more so in obviously capacity cases, but like criminal cases where you're looking at dealing with vulnerable witnesses. So I hadn't actually heard of that happening in the tribunal before. We've essentially tried to muddle through it and on the basis of the medical evidence ourselves do a ground rules hearing. I have on a number of occasions had the request that questions be prepared and written in advance. So me to prepare cross-examination, send over my questions, and the individual either have time and then be able to answer them orally or answer them in writing. I am not saying for a second that couldn't be a reasonable adjustment in a particular case. I have always resisted that in any case that I have been involved in, because it would take such a long time, so much more money, because people might not be aware, but that's not how I prepare my cross-examination. It isn't every single question's written out. I do it by topics, pages, etc., which is how a lot of barristers would do it. And also it really removes the adversarial process from what we currently have, where we are looking at how an individual is responding. Now, these are often cases where people are intelligent, have been engaged in the workforce and have been in lengthy grievance hearings, for example, or disciplinaries, and been able to respond. If I had seen something different, we might have taken a different view. And this is something that continues to come up, and the tribunal may well disagree with me in certain circumstances. But I've not seen one yet where I've thought that to me would seem a reasonable adjustment in terms of balancing the rights, responsibilities, fairness between the parties, etc. And what we have tried to do when that's been requested is see what are all the other reasonable adjustments that are being requested, because I've never had that just on its own, and agree as many of those as possible, and it's often all of them, and say, well, look, this is really reducing everything else down to try and make this a more manageable process for the individual, so we don't think it needs to go that far. In cases with child witnesses, for example, in the family courts, that is the process to a point that happens, but it actually goes further in that you would give your written questions to the judge, and then the judge decides what questions are allowed to be asked and answered. Now, you're dealing with different issues there. You're dealing with capacity issues because the person is minor. I'm not talking about capacity issues here. That would be a different approach in terms of how you would be running the claim. But it's never been suggested that a judge would then have that overview about questions and answers. And I could just see practically, it could expand things. It could be overwhelming for the individual. It might lead to what I was saying to avoid, which is coming up with extra points, because of course when I ask a question and I get an answer, I don't just ask the next question that I've got summarized on the page. I'll listen to that answer, I'll follow up, and I'll go down. So one can envisage where you would end up going back with a second round of questions, say, well, you said this, but you've also said that, so let me ask you whatever the question is. And I'm not sure that would necessarily be constructive, helpful, proportionate, reasonable, any of those things. So that's where, in my experience, advising, I've drawn the line before, but that's not to say in every case I would draw it there. But that sounds like what the tribunal is trying to achieve. And we've just had an additional comment here, I think maybe from the same person, may not be. A colleague has recently attended a ground rules hearing. The claimant was given additional flexibility about compliance with orders. That makes sense. And we will have to send cross-examining questions in advance of the hearing. It doesn't surprise me in a sense of I know that's been being asked for a while, and in the right case, I can see why a judge would order that. Judge wouldn't entertain future, I'm not sure what SO is, consideration if the claimant, strikeout consideration if the claimant continued to fail to comply with orders. That becomes a difficult one, because if somebody is able to prosecute their own case, you would probably want to go back to the case law on strikeouts and some of the presidential directions in terms of litigants and person are still expected to comply. And I would actually go to the CPR and some of the case law from the county court around the Mitchell-Denton tests, which I know we're not talking about Rule 3.9 non-compliance in the same way, but there is some general helpful dicta about individuals needing to comply with time limits. Now, of course, you're adjusting that on a reasonable adjustment basis, but that's got to be the starting point. And then it's how far do you adjust it? And if it gets to a point where you're not having a fair hearing or extra costs are being incurred, above and beyond what could be acceptable, you might want to go back to those sorts of points. If they're case management decisions, then it's a difficult one because you can't appeal them. And so what would be the consequences at the end of all of that you might want to appeal to try and get a decision on it? I suppose if you said it was maybe an error of law argument in terms of how the process was dealt with and then what decisions were reached in terms of the veracity of the evidence, really then you're getting into perversity. So it's a very difficult one. And I can understand how there can be a perception from the respondent side of things going too far. But I think that understanding of what happens in other courts is at least a way to explain to clients why this might be ordered to happen here. And as I say, I would be tempted to be saying, well, we might need to come back with some further questions and seeing, does that demonstrate actually that I'm right about what the problems might be and what you think the problems might be and why this might not be the most helpful. But that sounds like a challenging one. And I'm afraid without more, I probably shouldn't and can't comment any further. But thank you very much for telling us that. That's useful to know if they are two separate instances that these are starting to come up a bit more. Now, I don't think we've got any questions left in the Q&A. We are 5 minutes over, so not too long, and I hope that that's been a constructive session for everyone. There will just at the end be a feedback form or something like that pops up just in terms of what would you like to hear from us about in future. It might ask you how this seminar went. I'm not sure. I'm sure it's all anonymized, but if you would fill that back in, we do pay close attention to it. We like to try and provide sessions that are useful and constructive for you as well as for us. Yes, thank you very much for attending, and we hope to see you all soon, particularly with Rachel, to get to meet some of you at an in-person event. Thank you very much and good evening. And I think the recording will be sent out to those of you that have signed up already. But if not, do get in touch with Paul Clark here, and I'm sure he'll be able to ping it over to you. Thank you very much, everyone. Good evening.